At the end of August 2011, one of the greatest challenges in my life began. I'd initially brought my vehicle to the defendant's garage to get some repairs made. I hoped that I could keep the vehicle by getting the repairs, or if necessary, I was going to replace it. But I later learned that those repairs never happened. Twice my vehicle broke down after the alleged repairs were done. After complaints filed with the Better Business Bureau as well as the Office of Consumer Affairs, I had no choice left. I had to find an attorney and I had to file a suit. And this is the suit that I filed. I was fortunate to be represented by Mr. Gayle Jr. Mr. Gayle is the owner of the Consumer Law Group in Richmond, Virginia. Mr. Gayle is well renowned, and he is actually now listed as the Virginia's chair of the National Association of Consumer Advocates. This man has been practicing law for well over 30 years. And he is the author of the Virginia Lemon Law, or at least certainly the co-author. He recognized the merits of my case. He recognized the complaint. I made efforts to get this matter resolved with the defendant. I have multiple sclerosis. I was diagnosed with it in 2004. You know how they say stress will kill? There's no question that stress can impact a person. What I didn't realize is how much stress I was actually under in my battle trying to prove that they were not telling the truth. And that impacted my health to the point to where now I'm receiving disability pension from the VA. I've been deemed permanently and totally disabled. And although I had intended to work only months before this happened, by June 2011, my neurologist found no problem with my ability to work as an over-the-road truck driver. And I was stunned when he said in October of 2011 that my disease had relapsed. What truly was important for me is that both when I filed my complaint with the Better Business Bureau and with the Office of Consumer Affairs, the only thing the defendant had ever had to do was just simply say they did or they did not do something or nothing. It was not until I finally had an attorney where the defendant was now required to give something other than just their statement. With the complaint we filed, we attached these specific documents, which was information that had been provided or information we already had in our possession. These exhibits were attached as well as brought to the trial. We attached the invoice from the defendant where he showed the price that he paid, allegedly paid, for the engine. The alleged used engine was only $600, although on the invoice, the defendant alleges the price for the engine was $700. We attached the defendant's attorney's letter that was sent to me and the statements that had been made in that letter. As well, we attached the attached letter that came with the attorney's letter, that 6-page letter, and the claims that had been made in that. When the defendant responded, even in that answer, the defendant still wanted to stand to their position that there were only 2 repair requests that had been made. They maintained their position that they had put in a new time and chain cover, replaced the brake system. They stood with their position about replacing wheel lugs and lug nuts. The defendant, just as he did in his letter, tried to explain the elusive discount of $76.50. And just as they did in the letter, the defendant blamed it on their software system and how a mechanic had overrode this system. They stand in the position to say that what they did was in the book rates, standard book rates, and that it would have been more than what I would have originally had to pay had I not been able to receive this alleged discount. The defendant admitted in their answer that my request for documentation early on had been denied. They tried to explain that their reason for the threat of suing me for defamation was because I had said I had the evidence I needed, and if I didn't get that information that we would have to go to court. They felt because I said that I wanted to see them in trial if necessary, that meant they didn't have to participate any further with me. Not as though they ever did. None of my request initially was ever answered. And the strange thing was that their attorney had tried to raise an affirmative defense to suggest that the complaint that was filed was outside of the statute of limitations. And they asked the judge to dismiss the trial and that they be granted legal fees from me. The defendant never fully answered the questions that had been asked in our interrogatories and requests for production and documents. More than once throughout this entire ordeal, my attorney had to file or at least sent a good faith letter to the defendant's attorney, making them aware that if necessary, he would file a motion to compel so that we would be able to get the information that we had requested. When the defendant realized that we were truly heading for trial, they began to change their answers. They started providing supplements. Dates that had never been mentioned in either of the first two letters or even by their attorney were now being drawn in. The defendant admits, though, that around the end of July 25th, the vehicle had been towed there. But this mention of the 12th of August to say that I brought the vehicle there because I was having problems, for me, it was only trying to lay the groundwork to suggest that my truck broke down after knowing maybe that something was wrong with it. And the defendant, still, their attorney, stood the ground of trying to say that this complaint had been filed outside of the statute of limitations. In their earlier responses, the defendant claimed that they did not expect to ever call any expert witness to testify. Another supplement was now most incredible. The defendant has now said they just learned through their supplier, D&M, that they too has a problem with their software system, and that they just realized well past a year after they had given their answers that that invoice was a VIN number versus an engine serial number. That's interesting. The defendant used to sell pre-owned vehicles well past a year after they submitted the alleged engine serial number. They now recognize it was a car's VIN number and not an engine serial number. And most interesting is that they said they had just discovered, well past a year after we filed our complaint, they just learned that there was another mechanic that had allegedly repaired the vehicle. That mechanic no longer existed. In March of 2014, the defendant recognized that they would need to find out what evidence I actually possessed. The areas that had been circled with the blue is what I was required to answer. The information and evidence that I was required to provide. The other questions that hadn't been circled, Mr. Gayle was going to answer those based on legal position. By August 2014, my attorney had seen the first video I had produced, which tied all the information I'd given him together. And from that, the letter, written on the 23rd of November 2011, was sent to the defendant with the interrogatory asking about the facts and the statements. And surprisingly, the defendant said that all of the statements that had been made in that November 23rd letter were truthful. And that letter was sworn under oath as truthful. This is how we answered the defendant's request. The defendant already realized I had photographs of the vehicle. They wanted to know how many. Over 115 by the time we went to trial were presented, 11 video clips. They truly had a challenge, an issue with my raising the personal injury over my health. They wanted to see what medical information I had. And a CD had been provided to the defendant with 338 pages of medical information. The first time we responded to these requests, the defendant claimed that those discs with photographs, video footage, and medical records had been lost, that they never received them. I produced the information on those discs again, and we resent that information to the defendant. One of the main things is the defendant's approach by their attorney to try to have the trial dismissed with the belief that it was outside of statute of limitations. Tried to narrow my answering the question of whether or not I received the invoice the second time by no later than the 17th of September. Of course I denied that, because I didn't receive that invoice until the 19th of September 2011. After the pre-trial, my lawyer realized that for us to be able to raise the personal injury, one of the things we knew is we needed my doctor to be able to talk with my attorney so that he knew what his testimony would be. He had prepared and sent a HIPAA authorization form to both myself and to Dr. Tingler. I filled mine out and sent it back, but Dr. Tingler had a different position at that point. It wasn't a question of whether or not he would or wouldn't testify. The problem is we wouldn't be able to hold any conversation about my health issues unless both my attorney and myself were in Dr. Tingler's office or together in his presence. And so since we did not get that opportunity to have that conversation prior to the trial, Mr. Gayle pointed out the concerns for us to raise a personal injury without having that backed by a medical professional. The outcome and the backlash that could come from raising such a claim without having substantial backing was also then could be harmful to his profession. At a point, he was concerned about the challenges that we faced with this trial. In a case of fraud, the defendant does not have the burden. It is the plaintiff. The evidence must be clear and convincing. Any aspect of those claims, if they were challenged or if it brought a jury to question them, it would impact the entire trial. So to prevent Mr. Gayle from filing my case as a non-suit, I agreed to allow the personal injury to be set aside. To try to at least offset and compensate for doing that, Mr. Gayle went on and filed requesting at the pretrial that the judge at least give the consideration to pain and suffering. And he filed all the appropriate paperwork and attached it with law showing what supports the ability to request pain and suffering and why that should be granted. These are the documents that were in our possession as well as in the defendant's possession that were presented as exhibits in this trial. These are the documents that were presented as evidence. By the time we actually went to trial, an additional 7 to 10 or so photographs had been taken of the vehicle after the fact. I think is probably the most amazing thing, that during the trial, the jury saw these photographs, minus, of course, the handwritten notes. These notes and photographs had been taken earlier on, as early as June 2013. But these photographs were what I provided initially to my attorney, which showed that the labor and so many things really hadn't happened. And it showed that I had an expert witness, a master technician that was certified, had made these claims. And we had all those statements notarized in a letter that showed that these photographs were his true claims, true statements. During Mr. Jones' testimony, and as he stood there in the courtroom by the large television monitor screen, they had dimmed the lights in the courtroom, and I observed more than one juror dozing off as Mr. Jones stood and testified. The defendant claimed that this photograph was proof that they had changed the motor because they didn't turn out those bolts, they didn't remove the bolts. Their claim is that they installed that engine from under the frame because they said that the mounts and the brackets were already connected to the engine. That's their explanation as to why there were no obvious tool marks and why there was still dirt, grease, and grime left on those bolts. We were able to show the jury the evidence that these lug nuts hadn't been replaced. This photograph was not shown to the jury, but it does show that the defendant had claimed to inspect the vehicle in August of 2011 and claimed that it passed the state's inspection. All the documents that you see here were given to the jury because as the trial started, before it began, Mr. Gayle requested manila folders, and all 7 jurors was given a folder, and these pages were presented. And as these pages were presented in evidence, he ensured that each juror had one so they could follow along. We pointed out the difference of the $700 the defendant claimed this engine cost versus the $600 that they show it claimed it was paid for. Mr. Gayle questioned Mr. Fain on the witness stand, who sat there and said that his shop could mark the price up of a sale like that as much as 60%. And though we showed the differences, clear tool marks, we showed the older photographs before the engine was taken out. What was truly interesting is while he sat on the witness stand, both Mr. Fain and Mr. Anthony Collins admitted in court that neither of them have a current license as mechanics, that they both get training and school continued education. We show the jury the initial letter dated the 23rd of November 2011. We pointed out so many of the claims that had been made in that letter. The jury was able to follow along as Mr. Gayle pointed out certain examples, like the date that the defendant claims on the 8th of August 2011 that they had brought the vehicle in for repairs, as well as that they had replaced the battery with a new battery. Pointed out that nowhere on the defendant's answer of alleged repairs does it show a new battery being installed on the 8th of August, but it shows a new blemished battery supposedly was installed on the 16th of September. We pointed out to the jury the second set of interrogatories, how the defendant claimed that all of the different various statements made in that November 23rd letter are true, and wanted to add to a letter that was already 3 years old to say there was more that it should have read. And we pointed out how nowhere on the 15th or the 16th does the defendant's mechanic show any labor other than on the 19th. And that coincides with the date that the axle and CV boots were purchased. was really very strange is at the top left you can see where the courtroom was and where the judge's chambers are. As we took a break later that evening, I was leaving out to go outside, and as I came around the corner in the hallway, I passed by one of the jurors. Now there were 3 restrooms out there in that hallway. One was handicapped, one of course male, one female. But why was that juror out there in the hallway? Isn't there a restroom out back? Was he up towards the front of the building, near one of those 3 elevators? As you can see in this video, those 3 lights are where the elevators are on the front end. I'm very curious and I want to find out. I am going to ask that the surveillance footage of that day be pulled and reviewed from both the inside and the outside of that entire courtroom. That court building has cameras surrounding it, basically 360 degrees. This is the back area of the court. I don't know if the jury comes out those steps or goes in the basement area and comes out of the garage, but there are cameras all over the place. I need to find out, should that juror have been out there in that area at all? What is very, very difficult is that juror was later chosen as its foreman. By October of 2014, had decided then that they were going to bring in an expert. They made my attorney aware of the changes, that they realized this was now a VIN number. They claimed that D&M's used autos, their software system, also had a problem, just like their software system. They wanted to qualify a salesperson from D&M Used Auto and gave their alleged reasons why this person would qualify as an expert to rebut the claims made by my expert witness. They gave the information and started explaining their new changes of position. They claimed that a mechanic that supposedly they didn't know about, now they found out, and that mechanic no longer was there. What Mr. Gayle did to prevent this madness that the defendant was trying is he filed a motion in Lamont. That motion was sent and it had supporting information as to why the alleged expert witness or witnesses should not be permitted. That meant that not only should Mr. Steve Alley not be allowed to testify, but neither should Mr. Rob Fain or Mr. Anthony Collins. But that didn't matter, because the judge allowed them. The judge even allowed that we hold for long enough for Mr. Steve Alley to show up at the very end of the trial. He came in and sat and told the jury that they had no way of knowing what serial number was on this alleged engine the defendant claims they installed. None of the 3 people that testified for the defendant are certified or licensed mechanics. The jury saw and heard the evidence that we provided. But I'm also wondering, what else did the jury see? The defendant has far more money than I would ever imagine having. And for whatever reason that they wanted to take the $3,000 or so from me initially, I don't know. What's even harder though is I don't know what was it about me or about my witness that didn't register for this jury. The information and evidence you see is what we presented in that trial. But there were jurors that dozed at times when my expert witness testified. So what was it that they saw or didn't see? Perhaps they noticed my skin tone, and maybe that impacted what the jury decided they wanted to look at. Maybe it's because this trial was held on the 18th of December. We were only a week away from Christmas. Maybe they didn't want to deal with it for the 2 days that we had this trial set for. Perhaps my master technician, so well certified, maybe his skin tone, which matches mine, maybe that blinded the jury on what they decided they wanted to see. Is it possible that these 3 people, seemingly coming from out of town, were making up this incredible story? Had I made this up? Had Mr. Jones and I somehow collaborated and decided to fake this? The jury seemed to think we did not have clear and convincing evidence. And that is wrong. There is no way anybody should ever have to go through something like this. To go through what the defendant claimed and then to have the jury insult me, my attorney, and my certified expert witness. None of what we had to say made a difference.